rulings and stuff, is they've tightened up the rules, because there was a time, when I believe CDCR was kind of guilty for this, where they'd have wardens retire, and they'd come back and they'd work maybe, March, April, May, June in this fiscal year, and then they'd keep them on as a retired annuitant through, let's say, December. So they, in essence, work, 9 months out of 12 months. And CalPERS has redefined their rules to preclude those kinds of scenarios.
Should then 2.66 actually reflect what CalPERS regulations are, the 12 months instead of a fiscal year? Because you certainly can work the entire year the way it's written right now. Either limit it to 960 in a 12-month period, which would be probably accurate and comply with the law.
It would allow those who like to be able to finagle to stop finagling.
Right, it would, and that's just all I'm asking is that language be changed.
The way it reads, it says up to 960 hours in a fiscal year.
It says fiscal year in the regulations.
Yeah.
Thank you, Mr. Brown.
Yeah.
It says fiscal year in the regulations. I might add, Mr. Chairman, if I may. Thank you. Interestingly, the governor's office is actually promoting the employment of retired annuitants. I think they have a web page dedicated to getting folks who are retired, who have something to offer, even though they're in retirement.
Well, they need some institutional memory.
Absolutely. And so they have something to offer, but there are strict guidelines under which, and it's not the CalPERS rules. There are some of the CalPERS rules, but more in the government code is where it's found.
Well, the Pepper Act defined the law.
Implemented through the government code. Yes, sir.
Yeah, thank you, Mr. Chairman. Board of Supervisors, Dean Brown, Sheriff Warner. I do appreciate Mr. Burns, County Council, working on, and Mr. Egan putting together the policy committee. Obviously, this is an important topic for us. We rely on retired annuitants because they have I can't hire people off the streets that have the training that I need for boat patrol in the summertime, to help out extra help when we're short-staffed. These people, the ones I hire, have the training and experience that I have to have. We pay attention to what the law says. We comply with the 960. And I know it's fiscal year because the guys that do boating, we have to make sure each year we save enough hours for the early summer months the following year.
So if you use up their 960 hours in the first 4 months of the fiscal year, July, August, September, come next May, June,
They can't use them.
well, if it exceeds the 960, you're going to be in.
Yes,
Yeah.
exactly. So we're real careful how we monitor to those. And I'm not a huge fan, like no one is, of the double dipping. But the hard part for me to do the job we have to do, I have to use those
Well,
retired.
but I think the law intends that within a 12-month period of time, however you run that scale, slide it, how it relates, in that 12-month period of time, you can only work 960 hours. Period. So if the code is using fiscal years, that's how it's defined in the code. We should be consistent with the code.
Right. But again, I appreciate the convening of that policy committee. These things sometimes, we all might have a different perspective on how it would affect our agencies.
And I think what's important, Mr. Chairman, is in our personnel rules and regulations, we have not clearly addressed that basically new environment that has come forth because of the Pepper law and the other situations. So even though we might have had past practices that maybe reflected some of this activity, it's never really been clearly codified in one spot, and that's why I think it's important that we include it now.
Yeah, and we have made some adjustments on some of the other part-timers with the restrictions on hours per week and so on. So there was, I think
we drafted the proposed personnel rules and regulations with an eye toward imposing no more restrictions than that which the law requires, to provide for departments like the sheriff, who relies on these folks, as much flexibility as they can while still respecting what the law is.
And one thing we've clearly done with retired annuitants, in the past it was a gray area and it might have been all over the map how it was handled, but it clearly stays right here, and it's in what we have, but it's taken out of the code. If you have a retired annuitant, you're not paying into retirement for them, so that part of the budget saved. So using the guy to come back, you're not contributing to further retirement because he's already retired. And you're not paying him sick leave or anything like this there, so they're not accruing a bunch of other they get 960 hours, however they choose to use those. If they're sick this week, you have to scramble to find somebody to shift them, but you're not paying them because they've been sick, which we do with regular employees.
Okay, Richard, you get
Sure, I just wanted to point out that, and I think that Jim alluded to it, that a lot of people will refer to retired annuitants as double dipping, and that's not at all the case. When we hire a retired annuitant, basically what they're saying is they've worked, they've got their retirement benefits that they've earned, they're going to take those, and they're not going to participate in the retirement program in terms of contribution while they're coming back as an employee. So it saves the county money.
They're not costing us as much money.
It saves the agency money because the employer's share of the contribution does not have to be made, and the employee does not make a contribution to the PERS plan as well. So when people refer to retired annuitants as double dipping, I think that's basically out of ignorance because they don't understand how the system works. But it's not the case. It's the PEPRA laws, in my view, were just simply a way for PERS to
Not miss out.
build its dynasty and have more contributors to the program.
Okay.
I just wanted to make that point.
Thank you.
Thank you.
Speaking, I have a question for Richard.
Thank you.
When a retired annuitant comes back, what set of benefits does a retired annuitant get as they're not a full-time regular employee, they're not a part-time regular employee, or a substitute employee. A retired annuitant is a temporary extra help. Now, do we have to provide them health benefits?
We have to comply with the law.
No,
No, we can't offer them, we cannot offer them any benefits. We are precluded from offering them any benefits. Because if we do offer them benefits, then they slip away from the
That
retired
was the
annuitant
question, the
status.
point I want to have made. So when
Yes.
the retired annuitant comes back, they don't have all those benefits like flex. They don't get health care. They don't get sick pay. They don't get family leave. They don't get any of those kind of things.
Correct.
So when they are not there for whatever reason, they're just not being paid, and they're not racking up or using any of their 960 hours.
Correct. Now, Mr. Chairman, if I may, real quick, and I think
You may real quick.
this is important.
Do we pay workers' comp on it? I think you have to.
I think you're obliged to, yes.
Yeah.
But it's not a benefit that they receive necessarily. I would say, and I would direct the public to Boomerang, yes, that's it, boomerang.ca.gov, a website prepared by the governor's office. Boomerang.ca.gov, FAQs, particularly number 18, is the minimum number of hours I must work. And they expressly speak to 960 hours per fiscal year as the limitation of hours that you may work. And so that's the website that I referred to once before as promoted by the governor's office to tap into this retired
So they don't
labor
call
pool,
it
if you will.
retired annuitants anymore, they're boomerangs, huh?
Well, that's the name of the webpage. I call them people. Valued employees that happen to be retired annuitants.
Baby boomers, so now they're boomeranging, okay.
Okay, I think we've debated this issue enough. There's been a lot of good information come up. It's a very good debate. If there's no more questions from the public, I'll bring it back to the board and that's make a decision. I would support it myself. Dean, you support this, correct?
Yes.
You could-
But primarily for the reasons County Council said. It basically outlines exactly what the law says now. It isn't more restrictive, and that was my concern. I didn't want it to be any more restrictive than those.
Okay, thank you. Do we have a motion to okay this resolution?
What's our resolution?
16, 2015, is that it?
Oh, no, it's higher than that.
We've done that many.
Well, that's it.
Resolution number for this one is H.
We had one today already.
Just to pass it would be 66, 15-066.
I knew it was a 6.
Got a motion.
Yes.
I'll second it.
We have a motion and a second. Any more discussion?
Thank you, Bob, for getting that other one included.
Yes, sir.
All in favor, say aye. Aye. Opposed, say no. Ayes have it. One more item, H4, Public Works. Must be Peter.
Save the best for last.
We're getting hungry.
I'm back here to follow up from the item from last week. We were discussing the project for the courthouse modernization and annex building. Discussion was is that there was a firm had been selected to do that project, which is Lion Office. We're back here with the agreement for approval and to continue forward with that project.
The point being, for the extra copies, that there has been an exchange between County Counsel's office and Public Works Department and the contractor related to the terms and conditions of the proposed contract, which you find in your board packet. The result is that terms and conditions of the agreement that it appears to be being presented today by Mr. Heimbigner are a touch different. Maybe you can talk about what got changed. The point is what he's passing out reflects the changes as compared to what's in your packet. Is that right, Pete?
Well, the packet did not have a copy of the agreement.
Yeah,
There was no copy of the agreement. So
All
you've
right.
not seen a copy.
Thank you.
So this is the first time you've seen it. It's our standard boilerplate. When we filled out the proposals, the agreement boilerplate was out there for all the respondents to look at. Lionakis had already given us some language, and they submitted a proposal on the indemnity specifically. This is not uncommon that the indemnity section D6 under attachment D, page 3. I'm not going to get into the specifics of exactly what the attorneys are going back and forth about. I will leave that to the attorneys to make that, which Andrew Hott, who is our contract review for that for County Council, has seen the language that Lionakis provided, was okay with it, suggested a few modifications to that. Those modifications were presented to Lionakis. They were okay with that. So both parties at this time are okay with the language regarding identification. So this agreement is essentially ready for County Council approval. And at that point,
We have originals signed off here by Andrew.
Okay.
They were delivered this morning.
Excellent.
Came down.
And at that point, that will go to Lionakis for them to sign on, and it will come back here to sign on. So we don't necessarily, if you want to sign it ahead of time, that's usually the standard order that we do. We have the contractor sign after County Council, and then we have the county do the final signature on there. So we can track Mr. Pile down at a later date if so need be, as you already
What?
Before January 1st.
yeah, preferably in the next week or so on that.
Let's find out what happens.
Okay, question for Pete.
So we basically need to approve this final agreement and authorize the chair to sign when it comes back with all the other signatures.
Correct.
Got something?
We have a motion, do we have a second? Give me a second, one of you guys, come on, wake up.
Second.
Okay. Jeff seconded. Any more discussion? Questions from the public? Mrs. Spencer?
Yes. On January 21st, 2013, Supervisor Chapman led a tour of the old courthouse, the old court annex in the basement of the county administration building. On February 11th, 2013, Jeff Morris from NST told the board a master plan should be done first. On April 23rd, 2013, Supervisor Chapman pushed through a $20,000 contract for NST to study the space in the court annex for a new boardroom. No direction or instructions were given to NST except Chapman wanted to be in the new boardroom by June 1st. This is videotape and your minutes. Can we help? Requested a copy of the study and was told it did not exist. On December 10th of 2013, Martin Nichols, bless his heart, presented a reassignment of courthouse space to the board, defining where everyone would be moved. At the January 21st meeting, 2014, Chapman wanted a task force committee, and at this time he never mentioned digging up the old task force of many years ago. This task force, he wanted it called Courthouse Square Revitalization Task Force Committee. This committee never met. They were handpicked by Mr. Chapman. In a year, they never met, so he asked for this committee to be disbanded at the January meeting of 2015. On March 11, 2014, the Board of Supervisors set aside Mr. Chapman's new boardroom. On April 14th, CAO Richard Egan claimed that he expected to receive a needs assessment study in a few weeks. Again, from your minutes and from videos. Mr. Egan told the board that rather than spending the money to remodel county buildings, it might be possible to buy the BLM building on Riverside Drive. No mention at this time who would occupy it. 2015-2016 budget deliberately did not include any money for the new boardroom or courthouse projects at all. You did purchase the Riverside property by taking a $4 million debt. As of November 20th, 2015, there is less than $1.5 million left, and you have not repaired, remodeled, and have no idea what the cost will be to move 4 county departments into this building. They're not going to bring their old desk and their old stuff. You're going to buy new stuff that fits that space, and you have no idea how much it's going to cost. Probably it's going to take up most of that remaining loan money. You have today before you a contract for $133,000, and you intend to add that budget item so you'll make it legal, even though the RFP wasn't legal. Mr. Chapman wants his boardroom very bad, obviously over the history of his tenure. He wants this really bad. And he went behind your back and acted illegally. It would be in the best interest of the remaining 4 supervisors to table this issue until you successfully finish and know what Riverside's going to cost. Putting this on the table now is fiscally irresponsible. I mean, you've got to find out how much that 1996 building is going to cost, and it's going to be considerable. Then you have money to move other people. You can give Mr. Chapman his new boardroom. This will do it. But is it the wisest and smartest thing to do at this time for the people of this county? And I don't know why you would approve this today. I don't know why you'd add $133,000 to those 2 budget line items that you decided very distinctly not to put money into it this fiscal year. So to move ahead with this without knowing the money you're going to have to spend on Riverside, it doesn't have a sprinkler system. I can go on and on about the problems with that building, and maybe you haven't been advised to the problems with that building, that it's going to cost a lot more money than you've been told to get those 4 departments in there. And maybe you ought to save that $1.5 million until that's done. That would be the smart thing to do.
Thank you for your comment. Jim Hodge.
Many of my comments would be along the same line, just the fact that you have unknowns related to that build-out in that other building. It seems to me prudent to postpone this new supervisor's digs until that's taken care of. We also have a swimming pool, which is a big issue for the county. So you've already got 2 big things on your plate, and I'm not sure adding a third. To me, adding that third is risk. And so I personally would not want to see the risk, not knowing how much this other stuff's going to cost. The other thing is I don't know, to the future what our tax collections will be in the county if we're expecting far more money than we're receiving now. I don't see it that way. I don't see anything, growing. I see a lot of things that are more negative. We have a few more businesses, on Main Street, but I don't know if we're going to greatly increase revenue or if we're going to share a smaller piece between 3 people, whereas there used to be 2 businesses, now there's 3 businesses, and maybe each of them do not as well. So I'm not sure if that's going to bring in a lot of, money into the coffers. And in terms of kind of a master plan, looking at all of this, seems to be there ought to be more discussion about that and the cost of moving to the new building, and still dealing with the swimming pool, which is not really a finished item, it is in many ways, but I'd like to see those finished first before spending $133,000 on this engineering. How much do we spend with NST for the annex?
20,000.
20,000, right? Enough to pay your raises, basically. So I just think that the timing, I'm not really saying the whole project's bad, I'm saying the timing is not good.
Anybody else wish to speak on this item? Seeing none, we bring it back to the board for consideration. This gift being referred to as Jim Job of the new board group. I think we've got a lot more to do than that. I mean, we're talking about a lot of work being done in the courthouse, and I think the board group is probably a small part of it.
And we have it's not a new board, we're going to use the old historic board. So,
Maybe Rich, do you have?
Would you like my comments on that?
Yes, I would, very much. I have no.
Sure. I think the concerns about financing these improvements are not unique to the public. They're shared by all of us in administrative offices, and I think the board. We have had this discussion several times, and I know not everyone's present for all the board meetings and the discussions we've had, but we're in a situation where we are balancing risk, and obviously there is risk with taking on a lot of projects at one time. There's also, in my view at least, there's a more significant risk of not addressing potential liabilities that we currently have and have existed in our county facilities for a long time. And the trouble with that I see with the liabilities is if we have issues in those facilities now that result in losses, that's money that goes away, and we don't get to keep it. We don't get to use it. Now, if we proactively now take on the responsibility of improving our facilities up to some standards of accessibility for disabled persons and, frankly, for our employees that are working in those facilities every day, then at least we have something. We can mitigate some risk and hopefully have better facilities for the public and for our employees to work in that result in lower loss claims, whether that be workman's compensation, Americans with disabilities claims, et cetera, that you're all aware of. I think it's quite possible that as we get into this project, into this study, that will result in a budget for phasing of improvements in that courthouse, that we need to look at either extending the project or in phases and perhaps doing the most important things first, or additional financing. We don't know exactly what those costs are going to be. We don't know what we're going to get ourselves into until we take this step, and I think it's the appropriate measure to take at this point.
Richard, what would you give an estimate of the cost to redo the building?
To do the remodeling?
That we have planned.
Yeah, Tony can give you the exact amount.
Yeah. So, Tony Shaw, Deputy County
Is
District
it
Officer.
the number we have? We're being told we
So-
don't know this. But
so-
it's the number we have.
The answer is we don't know, and it's because we just finished the draft plans and specifications for construction, and the engineer, architect will come up with a construction estimate that will accompany those documents when we go out to bid. So we don't have a solid number, but we are on schedule with having those documents through plan check at this time. So I don't-
We did budget an amount. I want to say it was $300,000, but
yeah, Pete may.
600,000 is in your documents. 600,000 is what you told the public.
I'm not sure what we budgeted.
600,000.
600,000. It's in a lot of documents.
I'm not sure what.
Yeah, I don't have a solid number for you, and like I said, we're going through the process to get a solid construction estimate at this time, and we're on schedule with getting the documents through plan check.
what's the time frame on getting the solid numbers?
Pete, when we
Ben, I'd like to see if we get something early January. We're find out what the plan check turnaround time is. We're trying to expedite that and everything. We're also dialing in some other stuff that's not in the plan check as well right now. We're trying to run a couple things concurrently, or in parallel, I should say, instead of one after another. So early, and I'd say the range is probably that $400,000 to $600,000 range on that. We're trying to be as cost conscious with the project. The architect is very cognizant of our budget tightness on that, and just looking at everything. We're not going with top of line. We're going what's practical and it's going to give us a good, useful life on it, and meets the needs that also go long term.
And for the actual furnishings, I was under the impression that we got a plan for that.
We may be able to, some people have newer office stuff. We may be able to use that. It just depends on what each department has. And, there's some departments that replace stuff recently, then we'll be able to reuse that stuff.
Yeah, the assertion that we're going to go in there and buy everything brand new is...
I wouldn't compare us to the courthouse or the Hall of Justice. They basically went blank slate, brand new. We're not the state. We don't have funding like that, and so we're really
Well, a lot of their stuff was surplus, and we wound up with it. So we'll be reutilizing a lot of the stuff that we vacated.
We cut the imported African hickory to count out of the budget.
Okay, thank you, Tony.
You're welcome.
Mr. Raj, you have a question?
Yeah, I just have one more comment, and that's I would like to make sure that we've exhausted all other alternatives. Now, something I brought up before in the prior discussion was about sharing with the city council. The objection that was brought back to me was, well, they have other committee meetings and some other things that happen there. I'd rather see...
You're talking about the boardroom.
Yes, where the whole city council meetings, okay, but those are at night.
Yeah.
So this body doesn't meet that often. So if you had to, could you work it out? If you had to, could you work it out? Could you spend some money there, a fraction of what we're spending now, and have a nicer room and better AV, and use that, and maybe in the new Riverside building there is some kind of a room where you could have those other kind of meetings, the committee meetings or whatever that meet in city council now. Is there some way this could be done for a fraction of the money? That's what I would want to make sure that you've exhausted all of those other possibilities before taking on this expense and before taking on the $133,000 engineering fund that maybe or maybe it doesn't come to fruition.
Jim, I'll call you.
Well, yeah, let me, if I can partially address that, and I think address even a bigger issue. First of all, I think there's a lot of apples and oranges that are being mixed around in the problem. And I appreciate Mrs. Spencer's historical narrative. At the time that I initiated that discussion back in 2013, we've been sitting in this 600 square foot room with the court space that was abandoned by the court system when they moved to their new $37 million facility. Had over 10,000 square feet that had basically for the last 4 years has been sat unused or underutilized, and without any sort of organized, what are we going to do with the reutilization of the space? I've been clamoring for a long time for county staff, and it goes back several county administrators, that we knew well in advance when the courts were going to be building a new courthouse. They pretty much made that decision in 2003. By 2006, they were underway with their planning. By 2008-9, they were into construction, and they moved in basically in 2011. So it's not like something that just happened out of the clear blue. And during all that time, we kept talking about trying to motivate, county staff and the board and whoever else, the public at large, as to what are we going to do in terms of reutilizing that space. The board gave up its boardroom in the annex that it occupied from 1960 until about 1987 when they moved in this room in order to provide a second courtroom for the court system over in the annex. There's over 2,000 square feet there. And yes, initially, to me, I thought, it would be a relatively easy thing to do to go in there and repurpose the old courtroom. But by the time, the architectural people and the engineering people got involved, you got ADA, got all these things, and they turned what I thought would probably be a $20,000 or $30,000 project to, create a space that would accommodate more people and could be accommodating for the board. It wasn't going to change the board as much as it would change the accommodations for the general public. And yes, in terms of maybe buying some new furniture, we could retire those 1960s, early 1960s chairs that we've been using for the last 60 years. Maybe getting some, maybe even get some 1990 chairs for this boardroom. But that was the thing, and it became an obsession for some people that this was Jim Chapman building himself a boardroom. It has nothing to do with that.